Ladies and gentlemen, and legal enthusiasts and curiosity seekers, welcome to another electrifying episode of Legal Candy. I'm your host, Attorney Candice Colucci, and we have some nice treats in store for you today. Last week, if you remember, we delved into the intricacies of the George Floyd murder case. The reason why it had come up was because the officer, Derek Chauvin, had been stabbed while in custody, so it became very clear in our forefronts of our mind, so we started talking about them. We also have back on our show today one of our brilliant panel guests, law student Darby Mickus.
Another pleasure being here.
Thank you so much for coming. And we also have one of our amazing paralegals at the Colucci Law Group, which is Mary Catherine.
Happy to be here, Attorney Colucci. Thank you.
And she has been doing an intense amount of research, making sure we have all of our facts, everything we need to kind of talk a little bit more about what took place during that trial. And we also have another very special guest in the studio today. We have our esteemed colleague, Bella Minaj Colucci, who is our French bulldog. So this is the love of my life. Bella, say hello. Can you say hello to everybody? She's being a little shy. She's got her sweater on. So this has been a very emotional week for me. As anybody who's a dog lover, I'm sure can kind of have empathy when it comes to it. So on Saturday and Sunday of this week, Bella stopped eating and drinking and just broke and stopped our hearts. So my husband was panicking, I was panicking, and we took her to Blue Pearl, which I'm so thankful for Blue Pearl. We took her in there, and she was actually in the process of dying, and they were able to save her life and figured out she has Addison's disease, which is an adrenal disorder that now she has to be on steroids. But had they not figured it out, she would have died. And so she is in the studio today because I don't think I can have her leave my side, because it really did traumatize all of us, along with the office. Our office she's been there since she's been a baby. So my office was so great and just supportive in making sure everything was well for her. And I can tell you, I never thought it was going to be this devastating. I was pretty racked up about it. And I had trial that was supposed to start on Tuesday, and thank God for the judge understanding the type of pain that I was in. We were in the emergency room for days, and so I explained to him, the situation is like, I don't know how to say it, but I have a son, and I'm telling you, she is like a daughter to me, and so there's no way that I could try a case, and so the judge was willing to move the trial. So I'm very thankful for the judge and the system and Blue Pearl, and also the Animal and Bird Hospital. Her vet, Dr. Murphy and Dr. Valentine, are just fantastic, and they worked with Dr. Gainey at Blue Pearl. So we want to welcome Bella in, who's just kind of staring at the wall because she's obsessed with shadows. So she's seeing a shadow from the camera, and so she's literally staring right at it. Are you going to say hello, or are you just going to stare at your shadows? Huh? Okay. All right. So she'll be giving some legal advice today. As a legal disclaimer, anything that Bella says or I say or we say during the show should not be seen as individual legal advice to you. So if you have any individual situations, please reach out to an attorney. Nothing we tell you today creates an attorney-client privilege. So that is my legal disclaimer. So let's just get into it and talk about some of the stuff that we kind of left off with last week. So we were talking about Derek Chauvin. So we got some more information of what took place with him. So all we knew last week was that Derek Chauvin, who was sentenced to 22 years in federal prison for the murder of George Floyd. He was an officer who was charged criminally for his actions. As people remember, it incited a race, just a division and riots and war and protest, and it kind of divided the world during that time. And so the more information that we got was, what did we find out? That he was stabbed 22 times, which is pretty remarkable for him to survive that. And so the person who stabbed him, it looks like the alleged attacker is John Kursak. He's a 52-year-old former member of the Mexican mafia and an FBI informant. the interesting part about FBI informants is always that a lot of times there'll be an FBI informant that is part of a mafia, and they are now working with the FBI, and they'll be doing that for a little while, and then the line gets blurred between them doing their duty to the FBI. And so I think it's what happened with him, is that he was supposed to be giving information, then he decided to kind of veer off, and he plotted the murder of one of his rivals. So that's why he is in custody. And so he has now been charged with attempted murder, assault with intent to commit murder, assault with a dangerous weapon, and assault resulting in a serious bodily injury on the attack of Chauvin. He said that had the police officers not had gotten into the middle, because I guess they ended up tasing him during this stabbing, which took place in all places, the law library. So I'm sure Derek was in there, like a lot of inmates. They're brushing up on their legal studies, learning a lot about what their rights and remedies are. And so I would imagine that's what he was doing. And so he says had they not had intervened, he would have killed Derek Chauvin. And I guess he's also stating that he said he put thought into, he'd been thinking about murdering Derek Chauvin, and then he put thought into the timing because he did it on Black Friday, aligning with the symbolisms related to the social justice movements, which is just, it kind of just goes to show how just echoing this crime was, and how very many people are serious about the fact that they believe that it was racially motivated. And so even though now he's in custody serving his time, there's still people who think that he should have to die for his actions. And so so that's what takes place. So we know that now he's stable, he's back into custody. I think he's returned back into custody, and he has survived that. So now let's go back to where we were at in the trial process. That's what we wanted to do. On this show, we want to be able to give you legal advice that empowers you, but also kind of, I always feel like when the news is telling you stories, are really not giving you the nitty gritty of why things are happening. And I was so interested when I went to law school, as Darby is in law school now, I was so interested in criminal law. And that's the very first thing I did when I got out of law school. But so let's walk them through kind of some of the first things that happen. And one of my favorite parts of a trial is the very first thing that took place that in this Derek Chauvin trial started March 2021 is when it started. And the very first thing that happens is jury selection. So since I came from Stetson and I was on the trial team, I was trained specifically, and my specialty is in trial litigation. I've been trained by the best in the world. And so I specialize in it. When a lot of attorneys have never been to trial, a lot of attorneys don't understand trial. So I have been specifically trained in all of the pieces. And one of the areas that we get trained significantly in is jury selection, because we know that a case can be won and lost in jury selection. Have you learned about jury selection yet in law school?
I actually have not.
Yeah, because they don't. If you take one trial class, because there's no requirement.
It's in trial, trial advocacy.
Mm-hmm.
Yeah, that's where you learn things like that. But we don't get it a lot in criminal law or criminal procedure.
Yeah. And it's also not a requirement in law school to take trial advocacy.
Interesting, because as a trial attorney, you're contracted out a lot of times to do the work of other attorneys. Like they get it to the trial stage, and then you come in and fight for the rest of the case because they're not trained in that type of area.
Yep, absolutely. It's what I'm doing right now. So it's very common for an attorney you hire to not have trial experience or to not be a trial litigator. And so there are trial attorneys like myself who will come in right when they need it, like right before trial. So so it's not required in law school. Nobody talks about that. So jury selection is the very beginning part of the trial. And that is when you're determining who is going to be on your jury. So you have a constitutional right to be tried in a criminal case by a jury of your peers. And the way it normally works is you get 6 jurors if it's not a death penalty or life sentence. But in this case, with Derek Chauvin, there was going to be 12, and I think one alternative is usually, I think is what took place here. 1 or 2 alternatives.
They had 3 alternatives.
3 alternatives, okay, 3 alternatives. And that's in case anything happens to any of the jurors that they have selected. But the process is that when we start jury selection, they bring in, like, if you've ever gotten those letters in the mail, they're like, you've been selected for jury selection.
Is it weird that I was excited when I got mine?
Oh, yeah, no, it happens. And they can see it on your face when you go there. If you get excited for jury, we don't want anyone who wants to be there.
No, I was immediately told to go home.
Yes, exactly. No, it is. We're doing a lot of, I have a background in psychology. My degree was in psychology. So that's what's so interesting about jury selection is there is so much about jury selection that comes down to the psychology of the people that are there. And so if you're too excited, we want to know why. And it usually means you probably know too much about the system. And we want people that are really kind of blinded by the system, don't know a lot about it, because we don't want anything that you can take from outside the four corners of this courtroom. We want to be telling you everything. We want to be telling you the facts of the case for the very first time. We want to be telling you the law for the very first time. We don't want to find out that you are obsessed with Law and Order and you're like, I've been waiting for this moment because I have been watching Law and Order and Lifetime Network for a really long time, and I am sure that I can try this case, because that is all hogwash. What you've seen there is not correct at all. Mm-hmm. And so the point is that the idea is to get a jury of your peers that are promising to be impartial, that are promising that they are not going to be biased. So that is always what we're looking for. So the way we do it is we start asking certain questions. So both sides take time and we start asking the jurors certain questions. And so we actually have the questionnaire. So usually there'll be a general questionnaire that's given to all the jurors, and they'll answer those questions. And then as attorneys, we get these answers that give us an idea of who these people are. So a lot of times it'll be general. Who are you? Where do you work? You know, give us a little bit about your family history, your history, and then some more general questions, especially in a case that was this high profile. Some of those real important questions we want to know is, how much do you know about this case before you walked in today?
How do courts circumvent that when it is such high-profile cases? Like, how do you get jurors that are going to be impartial and not have a bias?
So it all depends on how big the story is. So with something like George Floyd, it would have probably been impossible. So we start going through jurors, and it probably would have been impossible to us to find an entire jury of 12 that didn't know about George Floyd. But so that's what we first try to do. We first try to find people who don't know about it at all. Then if we've gone through a bunch of people and we can't, then the next thing is we're going to find people who are still going to say that, yes, I know about this and I've heard a little bit, but I still can be impartial. And I can still sit here and follow the law. That's another huge thing, is we want to know. So like there'll be questions like we've asked before, you know, like if this has to do with a murder involving a police officer, one of the number one questions we want to know is, anybody in the juror ever had a family member who they believe has been killed by a police officer? That would be one of the questions we ask. And if somebody raises their hand and says yes, and they're like, yeah, my brother was killed, then we start asking more questions, because we want to see, is this person going to be able to be impartial? Majority of the time, the answer is no, they're not going to be able to be. And it's not that they're a bad person. It's the fact that we take these jurors as they come and with whatever happens in their life. And so that will be someone who will end up not being able potentially to make it onto the jury. Will be somebody who has a personal attachment like that to facts in this case, because we want to make sure that we're following the constitutional right that this defendant would have. So there's a lot of questions about, have you heard of George Floyd? Did you participate in, there was a lot of questions, as Mary Catherine was saying, there was a lot of questions about, did you participate in Black Lives Matter movements? Were you protesting? Like, those are things that inherently would have seemed like somebody was really going to be biased if they were standing and actually protesting on behalf of Black rights. And so it doesn't mean end all be all they couldn't have made the jury, because there's an opportunity once let's say that I'm a prosecuting attorney. if I ask them questions and I feel like there's a bias there, then the other side gets an opportunity to rehab that same potential juror. And they can ask him other questions that maybe bring him back to go, well, do you think you can follow the law? And if the juror member's like, yeah, I can follow the law, then we'll wait to see what a judge says when he sees that, if he thinks that person can still be impartial.
When I was researching this, I kept reading that the jury was a unicorn jury. I kept seeing that everywhere. So what does that mean? Can you tell me what that means? Because I kept seeing it everywhere. This was a unicorn jury. Does that mean that it's highly ideal because of the split?
I think so, because of the racial split between it, and I think that they felt like so they had a really even jury between blacks and whites, and then also it only took a day to do jury selection. In a case like this, you would have thought that they would have potentially taken more. They would have had to have gone through a lot of witnesses, but it seemed like the biggest issue that happened during jury selection was that they had attempted to ask to move the trial, and we talked about it last time, and that was denied. So the defense says, listen, there's no way, God's green earth, can we get a fair jury in this county. There's just no way. It's on every single news. It's on every single radio. It's on every single street corner. If you go into a gas station, people are talking about it. If you go into the cafeteria, people are talking about it. So they felt like they couldn't get a fair jury in that city. So they'd asked for a change of venue, and that was denied.
Yeah.
Which I would say that I can see how that ended up being grounds for an appeal. So after it gets denied, then the trial goes forward and he gets sentenced to jail. And then that's part of an appeal. That's part of their appeal, is that they're saying that here are the things we believe were done incorrectly during this entire process. And one of them was the failure to change the venue. And I would say that I can understand that, because I definitely think that became a huge issue. And here is why I think it became a really big issue, was because we found out that there were some jurors that had talked about the fact that they were really scared of finding him not guilty because of the backlash. So if you think about it, where you're living would have a huge impact on that. So the fact that the jury is in that city means if they find him not guilty, they're literally walking out onto those streets that it's the most heightened emotions are in that city. So if the case had been tried in a different county or different city, then that could have been less of likely of an issue. So I do see how it became a constitutional issue and how that became an appealable issue. It was ultimately denied, but I do see how that can become an issue. So they choose the jury, and then they start going forward into opening statements. But before they do that, we're going to talk about motions in limine. So motions in limine are going to be, what people don't realize about trial is that the way trial works is not everything comes into a trial, which is why when we're choosing a jury, we're looking for people who haven't gotten information from
outside resources.
Yes.
That's why in the jury questions it says, what's your main source of news?
Yep.
They want to know. We
want to know what type of news are you listening to? Are you listening to
Perez Hilton?
Perez Hilton? Are you getting the celebrity version of it? Are you listening to Fox News? Are you listening to local news? What are you listening to that could potentially have created a bias in your mind that can now affect your ability to be impartial during this trial? So not all evidence is allowed to come in, which is why it's so important that they haven't got anything from anywhere else, because there's a lot of times evidence just gets thrown across on news that doesn't eventually meet the requirements of the criminal rules, which you're learning all about those criminal rules right now, which has got to be interesting, right? It's got to be interesting when you realize how much isn't allowed to come in.
It's really kind of crazy how you can have all this evidence, but there's all these safeguards by the Constitution that prevent certain evidence. I mean, the exclusionary rule and all this other stuff where the news is going to talk about police misconduct and bring in this evidence, but you can't bring it in trial because of things like the exclusionary rule and protections of the Fifth and Sixth Amendment. Like, they can't bring them in. But so that's why the jury selection is so critical. because you can't have someone that's seen the news and seen all this police misconduct and think it's going to be brought into trial, but it's not.
Yeah.
And they can't have that part of their ultimate decision.
Yep. Okay. So we are going to go to a quick break, and then when we get back, we'll talk more about what are some of the things that didn't come into trial, why, and then what were some of those pivotal facts of probably why the jury found the way that they found. We'll be right back after this break. All right, we are back with Legal Candy, and right now we are focused on the trial of Derek Chauvin, who was convicted of murdering George Floyd, a former officer he was. So we were just talking about the rules of evidence, and I always like to say this, when I first learned about the rules of evidence, the interesting part about it is anything that looks too bad can't come in, and anything that looks too good can't come in. That's really the ultimate of it. If something lacks credibility, it can't come in. So really the idea is to create this boxed in artificial world for the jury, that we're presenting everything to them that's in accordance with the law, that forces them to make a decision on if somebody is guilty or not guilty in a criminal case based on those events only. And that's huge. So a lot of times what we're doing is we're going, what is irrelevant? Certain things can't come in if they're not more or less likely to find him guilty or innocent. Those facts shouldn't be coming in. If anything makes him look too bad, like a lot of things he may have done in the past, those things can't come in. So some of the stuff that happens, motion in limine is one of the places that you take into account before you go to trial, of you're literally going to the judge and going, listen, Your Honor, here's where we think some of the things are going to potentially come in, and we don't want them to come in, and here's why they shouldn't. So some of the stuff that never came into trial was the fact that Derek Chauvin had been actually fired, that the police department's decision to fire him, that never came in. Also, what never came in is the evidence about the civil suit filed by George Floyd's family and the fact that they got that verdict. So the reasoning is that the judge had decided that he believed, based on the rules of evidence, that those things were irrelevant. They're relevant to the fact of, if on that day in time, did Derek Chauvin violate his obligation as an officer and actually murder George Floyd? Those things aren't going to make it more or less likely, because they actually took place after the death. So him getting fired later on, that's something that happens afterwards. Same with that. So a lot of things that happen afterwards usually aren't allowed to come in. So there's some other evidence that doesn't come in, and so then they start the trial, and it ends up being about 2 weeks long. And there's 45 witnesses that I think end up testifying during the 2 weeks. And so I thought one of the interesting parts, and I know this was talked about a lot, was that we know that we have a lot of people who testified were the people who were out there watching it. And that was just heart-wrenching to hear their testimony of watching somebody die right in front of their arms. That was what you were listening to kind of over and over and over again from these witnesses that were just saying that they watched Floyd that was terrified, scared, begging for his life, couldn't breathe, and that a lot of focus was on Derek Chauvin about the fact that they felt that he just stared at them with a blank stare, like had no emotions towards George Floyd. And then of course they repeat that they had said several times he couldn't breathe. And so one of I think the witnesses had stated when she was on the stand, and she says that when I look at George Floyd, I look at my dad, I look at my brothers, I look at my cousins, my uncles, because they are all black. It's been nights I stayed up apologizing to George Floyd for not doing more and not physically interacting and not saving his life.
And this is a minor too.
Yeah. This is a minor that said that. That it was that traumatizing in that moment. And I think that what I thought was so beautiful about that quote is I honestly think that quote is what sparked the racial protest. I think that concept of people watching George Floyd die on camera for the 9 minutes that his neck was literally being kneeled on by the officer. I think that's the moment that people started feeling that could be me. It could be someone I love. And then they felt how unjust it was. Not just what was happening to him, but the fact that it could be any of us, especially coming from a Black perspective of saying that they felt like they were not treated fairly. They weren't seen as being valuable members of society, that nobody cared, because that's what you're watching. You're watching a whole set of officers who are engaged in supposed to be police behavior, who couldn't care less about the safety of the person they're supposed to be protecting. So there was a lot of witnesses who talked about what they were seeing. And then I thought this was good, Mary Catherine, you were talking about the fall of the blue wall. The fall of the blue wall. And when you do criminal defense, it was remarkable for me when I first started criminal defense, as you'll learn when you start getting into law, the things that you learn, you're taken aback by it. And one of the things I had learned when I was doing criminal defense is that blue shield, brothers in blue, is a real thing. It is a real thing, and they don't want to rat on each other or cinch on each other. If you do, there's ramifications of it. And it's not that I would say that I don't get it, because I understand. I've been part of the teams, so I understand that we're supposed to ride together, die together, and fight together, and we need to have a unified front. But where does it end?
Where's that line?
Where's the line? Yeah. Yep. Having each other's back is one thing, because in the instance of somebody's life's on the line, you're going to need to be able to depend on the person beside you. But when you're protecting each other through decisions that endanger the life of the public, then when do you stand up and say, that's not okay, that's not enough, and I'm not going to back that? And I think that's what we saw. So when Mary Catherine said the fall of the blue line, which we heard a lot during this trial, that is really what you were watching, because there were numerous officers who took the stand. You have the police chief of Minneapolis who takes the stand and states that, in essence, that Derek Chauvin was a rogue cop during the final moment. A rogue cop during the final moment. And I think everything became pivotal. And he says, to continue to apply that level of force to a person that in no way, shape, or form is anything that is potentially going to be moving or becomes dangerous is certainly not part of our ethics or our values. And so that is what becomes repeated over and over and over again, is that line that got crossed from Derek Chauvin. And I think as we get into the more medical side of what takes place, is we see where that's at. I think everybody who's watched that video of the last moments of George Floyd's life sees where that line is at, of when he finally stops moving. All three officers are still on him. Derek Chauvin is still on his neck, and you can see the life gone from George Floyd, yet they're still pressing on his neck. And so that officer goes on to say that there is an initial response of reasonableness in trying to get him under control in the first few seconds. But once there was no way, any resistance, and clearly when Mr. Floyd was no longer responsive and even motionless, to continue to apply that level of force to a person handcuffed behind their back, that in no way, shape, or form is anything that is not our policy. So he just continuously kind of goes over that. And then he goes on to say that we absolutely have a duty to render that type of aid. I think when I was watching the trial, that's when I kind of knew, when the police officers were testifying one by one and saying that what he did was unreasonable and violated, now we're talking about those constitutional rights, your Fourth Amendment right to be free from an unreasonable search and seizure or excessive force. That's when you started realizing that there was no hope for this trial at this point in time.
No, not at all. I mean, this case really set precedent towards all police officers and all kind of bodies of government where you really should speak up when something's going awry. Mm-hmm. And it's really your duty at this point now that you can't just let misconduct go unchecked.
Yeah. And I think what sparked that so much was the only thing that I think kind of shocked me kind of more than anything in this whole trial, besides what happened with George Floyd, was the fact that the 3 officers were all found guilty, the 3 other officers, because I felt like I understood, but a lot of stuff was happening there. And it's like the guy that was on his legs, it's like it was a lot of things happening all at once. So I think you're so right. The precedent that it set there was you will be held responsible as an officer for sitting back and not actively doing something or just listening to others' orders, right? Because they all testified that, hey, that I think one of them was trained by Derek Chauvin, had been trained by him. There was
a trainee in there.
Yeah. So he's going, my mentor, the person who trained me, is telling me this is what I'm supposed to be doing. And so it really kind of, there was a lot of reform that happened afterwards, as far as they're not allowed to do chokeholds anymore. Those kind of things. More de-escalation measures were put into place. But it really did, I think, open up everyone's eyes, especially looking at other officers, to go, listen, if you engage in this, whether you're following orders or not, you can be held criminally responsible for it. And so I think that they were definitely shocked that all 3 of them ended up being found guilty of failing to render the aid. But the other person who I think was really moving, and I don't know if you guys had seen it or not, is there was a firefighter, an off-duty firefighter, a woman, who took the stand. And she said, and this was the parts that I didn't know until the trial happened. I did not know that this was the extent that we were dealing with, the failure to render aid. Because when you're looking at it, even from the video perspective, is you're going, listen, there's a lot of stuff going on. Everyone's yelling, they're saying this and that. You're trying to keep this, your defendant, you're trying to keep this defendant, not moving. You don't know if he has weapons or any of those other stuff. So I get it's a lot of stuff happening at one time. But when she testified, I was like, oh my gosh, all of the things that were taking place. So this off-duty firefighter said that I happened to be there and I happened to try to render aid, that I was yelling to them and they told me to back down, that it was pretty much made her feel like it was none of her business, that she didn't need to get involved. And so she said, and she was crying on the stand because they asked her how did it make her feel, which, by the way, I would have objected to that, just so you know. So those are things that are potentially irrelevant. How a firefighter standing on the side feels when she's told she can't render aid would be irrelevant to the fact it just does. So I would have objected, but there was no objection. And if you don't object during trial, you don't preserve it for an appeal. So you have to make sure your attorney is paying attention and knows what they're doing, because it can severely be detrimental. But it was just, you could feel what she was saying. She felt helpless. She felt like all the training she'd ever done was for these exact moments. And so she said she got to a point where after they had told her that she didn't need that to leave it alone and to not help them, she ended up saying, well, I'm at least going to try to tell them what they should be doing. So she tries to now from the side yell at them to say, here's what you need to be doing. You need to pull them over. You need to turn them over. You need to do all this stuff. And then she ends up calling the ambulance herself. Wow. But that I thought was really pivotal, because it goes to, remember we talked about in criminal court, they've got to show this mens rea, which is really the mental aspect of the intentional criminal side, is that's what you need to be charged criminally. And that's what ended up happening here, is finding that moment to where Derek Chauvin goes from doing his duty to now having criminal intent, or a deprived mind, as we talked about that before. And I believe that those are some of the triggers, is that not only do you have the people saying he's dying, he can't breathe, he's telling you he's dying and he can't breathe, and now he's not moving at all. But you have a firefighter saying, guys, he needs my help, because they're officers, so they're usually trained on like regular CPR and like that. But she is a qualified professional that was right there. That had they let her, that to me was where I think everything came crashing down. Is had they let her intervene, then that his life could have been saved, and that they made a conscious decision to tell her no. You are not going to be able to save his life, and we're not going to let you. Where I think that's where it really becomes that they find themselves in the most culpable kind of scenario there.
A side point here, don't you think it's incredibly ironic that if she could have done this intervening act, that there was a chance George Floyd could have lived, and then here you have Derek Chauvin in custody and being stabbed, and because of a police intervention, his life is saved. It's very ironic.
You're right.
And it's very disheartening because, that's why people, I think, are so upset, because they're like, if you would let other people intervene, it could have saved another life, but instead it saved your life.
You're right.
And people are, I can see why people are so unrested by it.
Yeah. I wonder what Derek Chauvin would say. Like, I wonder if he wanted his life saved. I mean, if he's in the legal library, I can usually tell you that you're fighting. Like, that's usually what the legal library means. Like, it means we're going to get, as attorneys, we're going to be getting handwritten motions on piece of paper and pencil, which, bless their heart, they usually do a decent job of that. But he's obviously fighting for it. But you're right. The reason why he's now alive is because the system worked the way it was supposed to work to some degree. But when the shoe was on the other foot, he didn't do that.
No.
It is definitely ironic.
I wonder if he was in there filing that motion.
The motion
the motion to vacate the federal conviction.
Probably
he did
so.
File that motion, and maybe that's what he was doing.
Yeah, no, I'm sure they're always researching to figure out what they can file, what their rights are. So there's no telling what he was looking into. So the other big kind of thing that we saw during the trial was, and this was kind of, to me, I felt it was disheartening, was any idea, and part of the defense was not only that they felt like he was doing his job, which everyone said he wasn't, Derek Chauvin, but there also was testimony to the fact that they believed that potentially he wasn't killed that way, that he was killed because of the drugs that was in his system, an enlarged heart, all these other stuff that they said those things were what took into effect, and those are what killed him. And ultimately the jury believed the medical examiner, who stated that absolutely no, this was based on the fact that Derek Chauvin's knee was on Floyd's neck and restricted air to the entire system and everything, and that's literally how he ended up dying. So then what other people always ask me about is that Derek Chauvin does not take the stand.
He decides not to testify, and I found this incredibly shocking to me. And I know we've discussed outside of this radio station about not putting your defendant on the stand and whatnot, and how it can be detrimental. But I really felt like this was a Hail Mary approach. And I really think Phil Turner said it best, a former federal prosecutor from Chicago. He says he has nothing to lose, given that the video is so damaging. You've got to get up there and give an explanation. It's a no-brainer. And that's really how I felt. Why would you not want to elicit some type of response from the jury? And I think it was really disappointing to the jurors. I think they really wanted to hear his side of the story. Whether detrimental or not, I think that really painted a picture for them, where they're like, it kind of elicited a guilty verdict for them because he didn't speak his mind.
Okay. Well, we'll talk more after the break. We'll give you a quick break, and then we'll come back and we'll talk a little bit more about why did Derek Chauvin not take the stand, or potential reasons. Welcome back to Legal Candy, where we are talking about Derek Chauvin, the former officer who was found guilty of murdering George Floyd. So Darby, our esteemed legal student, was just talking, and she has brought this up several times to me about Derek Chauvin not taking the stand. So the way that it works is is that a defendant in a criminal case has the right to take the stand or not. And it's under usually what they'll claim is you have a Fifth Amendment right to being free from incrimination, so self-incrimination. So that's one of the reasons why someone won't take the stand. But ultimately, in a criminal case, you don't even have to plead that. You can just say, I don't want to take the stand. And it is really hard for people to understand why a defendant would not take the stand in their own defense. And I can tell you, as a former criminal defense attorney, it really is a double-edged sword. Because if you think about it this way, is that it is hard for a human being to do two things: to defend their actions, but also show empathy for the person who has been harmed. And that is really hard to do. So if he takes the stand, one of the hardest things is going to be, he's not a professional actor. It's not, one day we'll go over the Johnny Depp case, but that was literally two actors doing a trial that could have been scripted. I mean, between her cueing, the crying, him laughing, it was just, that's what it is. But real trial, when you're sitting there, is emotionally taxing for people, especially when your life is on the line. So he would have spent the entire time trying to defend himself. And the jury would have watched it as, how dare you try to defend yourself when this man died? And it's a really hard thing to do, because unless he was a great actor, it's almost impossible for a defendant to do when they take the stand. And cross-examination is one of the scariest things. So he may have done well on direct examination. So if I was his attorney and I was asking him questions, we would have prepped for a really long time. I would have told him the questions. He would have been able to answer them. I would have talked to him about, hey, you got to remember, you've got to be at times talking about the fact that there is a life that has been taken here. Direct examination wouldn't have been the issue. It's cross-examination. It is when the prosecution would have come on cross-examination and they would have drilled him. Their job is to call into question the person's credibility, make the person get angry. That's another huge thing, okay? But the other thing people don't realize also is that when we talked about evidence, we talked about sometimes certain things don't come into trial. Well, certain things aren't allowed to come in. But if you take the stand, we call it opening the door, which means if you take the stand, what now happens is you've opened the door to your credibility, your past.
Oh no, is this where they can impeach you on prior
bad
statements
acts,
and everything that didn't come in?
Yes, so now that he takes the stand, his credibility is at issue. And he had prior instances, as you were talking about before, is that he had prior incidents where he had been admonished, he had been in trouble with excessive force, with a juvenile, I think that you were looking at.
Yeah, they had a 14-year-old boy, a mother called about a situation of abuse, and he came in, and without any restraint from the 14-year-old, he just did another unreasonable force.
Yeah.
So it's a pattern of behavior at this point.
Yeah, so that doesn't come in, that wouldn't have normally came in during the trial. But now that he takes the stand, if he dares to say something like if I'm cross-examining him, I'd be like, you'd agree that you don't always follow your policies and procedure, right? And if he goes, no, I do. I do follow the policies and procedures. Now he's lied. Now I'm allowed to impeach him with that exact evidence about the juvenile that he had been in trouble with. Mm-hmm. Now, it wouldn't have came in normally during the case, but now that he's taken the stand, it opens the door to all of that.
All the evidence.
Yep. So that is another reason why a lot of times criminal defense attorneys will say it is not a good idea to take the stand in your own defense because it's too personal to you. And then when you start getting cross-examined, who is calling into question everything you did, then you start getting angry. And guess what happens? The jury's now watched you defend yourself to say why everything you did that they just watched on camera was okay. And then now you're getting angry because the other attorney is getting you riled up. So now they're seeing this anger in you, and it's unpredictable what people will do when they're defendants on the stand. So that's the reason why. And trust me, it's a hard decision to make, and a lot of times it's not made until the opportunity comes for him to take the stand. So after, it's usually the very last thing. I mean, this is how intense trials will be. There can be a decision that he's not going to take the stand. We build our entire case around him not taking the stand. And then as the defendant watches the case, and we get to the very end, so after the prosecution finishes their case and we start the defense case, if we were going to call our witness, it would be that we usually call him the last. He'd be the last person who would take the stand. And so at that point in time, we talk to our client and we go over again. And there are sometimes our clients have been like, no, after everything I saw, I have to take the stand. I cannot not take the stand. All we can do as an attorney is advise them, but he has to make the ultimate decision. And it's such a big deal that when it is decided if he's going to take the stand or not, if he decides not to take the stand, then he will be questioned usually by the judge just to clarify and make sure that he is deciding not to take the stand, that it is under his own rights to do it or not do it, and that nobody has forced him or offered him anything in exchange for him either testifying or not testifying.
Knowing
because it is huge.
voluntarily.
Yeah, knowing intelligently and voluntarily making that decision. In this instance, he had decided not to. And it also comes down to little things. I know this sounds crazy, but this is how a jury is he doesn't look sympathetic.
I was going to mention that. Like, yeah. I saw that in one of the jurors' testimony that the Darnella Frazier, she mentioned how cold and his demeanor seemed heartless. Like, I mean, as his defense attorney, I don't know if I'd be comfortable putting him up on the stand because I think he would come across as the video showed him as cold and heartless and uncaring. Yeah,
I've had to tell criminal defendants and be really honest with them and say, you have tattoos on your face. There's no way that you're going to get the sympathy you want from a jury. You've got those tear. You know how many clients I've had that have the freaking tear marks on their eyes. Besides watching Crybaby, okay. I remember when I first learned it, watching Crybaby as being young, what these tears meant. I was like, anyone who's watched it knows this. So that being said, I'm like, you're talking about a jury who probably all watched that movie, and now you've got 7 different tear marks here. You've got tattooed across your forehead, never surrender. You know what I mean? It's like, it's these things that I'm like, I hate to tell you that my job is to tell you how I can best advocate for you. And in this instance, you taking the stand would not be the best way for me to advocate for you because of the way you look. And I would say Derek Chauvin, hate to say it, he doesn't come across as looking that way. If you've ever seen a defendant take the stand and by the time they testify, she's got her hair's in pigtails and she's got glasses on, because aesthetically looking to a jury is huge. So he doesn't take the stand, and they find him guilty of all the counts that we had talked about. He's found guilty of second-degree murder, and then third-degree murder, and then I think it was negligence, culpable negligence also.
Yeah, the manslaughter.
Yeah, manslaughter. Second-degree unintentional murder, third-degree murder, and second-degree manslaughter. And so he's found guilty on all of those. And we'll just quickly talk about the jury. So afterwards, it's always interesting. I love if you get the opportunity to hear what a jury has to say, you have to be really careful about that. But it's so important to understand what were those pivotal facts in the jury. And Mary Catherine, what was some of the stuff that you had found about why the jury ended up finding him guilty?
I'm going to play this audio clip.
Yeah.
Okay?
Yep.
I brought up to the fact that this is not what he did, but more or less what he didn't do. He did not provide life-saving measures for George Floyd when he knew that the guy was in pain or needed medical attention. Even the firefighter that was off said, check his pulse. Well, then they checked his pulse and they said, well, do you want to do anything? No, we're leaving him here. He had ample to roll him over and start CPR, and he didn't. He didn't move one bit. And even when the EMS came up and checked him, he never even got up. And he knew he had been lifeless for 30 seconds to a minute. He still never stepped up and let the EMS come in and do their job. He had to have the EMS tap him to get up. That to me said more than what he actually did, that he just didn't do anything to help him at that time.
Why do you think that was a light bulb?
Well, when we were in deliberations, and Jody did bring that up, and we did look through everything very, very carefully, what I thought about is something that was said during the trial, and that is Minneapolis Police Department has a motto. And if I'm understanding it correctly, their motto is, in our custody, in our care. George Floyd was in their custody. He was never in their care.
Oh.
And that, for me, it just hit hard.
Oh.
I don't feel like they ever cared for him.
Yeah.
There was a point where the prosecutors pointed out when the life left his body on that video. What was that moment like?
I had a big gasp. I've never experienced anything like that before. I don't think any of us have. It was very, very traumatic, and it just hurt.
Yeah. So that's literally where I think, in our custody, in our care, I think that we all just kind of hit the nail on the head, is that that's exactly where it became so pivotal for them, was the fact that there was no empathy shown by Derek Chauvin and them to protecting the life of somebody who was in their custody. And that's really where it all changed for them. And it's true. He was in their custody, but he was never in their care. And that's so sad. So I want to thank everybody for being here, for Darby coming. We're going to have her on more different times because she's got all that great, fresh legal knowledge from being in law school. Mary Catherine, all her research. And Bella Minaj Colucci's here. And she did a great job, gave a good amount of legal information and analysis. So join us next week when we are going to go back and talk about some of the insurance claims issues, how to better protect your rights, what to do and how to navigate the storm or any of the hurricane issues, as we still have people who have not been paid from the hurricane claims. So see you next week on Legal Candy.